Welcome to the Rational Egoist. I'm your host, Michael Liebowitz, and it may come as no surprise to my listeners that I have an interest in the subject of qualified immunity, which is the immunity that government employees are entitled to by, well, we'll get into why they have it. But here to break it all down for us is the Senior Vice President for Legal Studies at the Cato Institute, Clark Neily. Welcome to the show.
Appreciate it. Good to be with you.
Well, what is qualified immunity?
Yeah, qualified immunity is a defense that the Supreme Court invented out of whole cloth that enables police and other government officials who have been plausibly alleged to have violated people's civil rights to avoid liability and, in fact, to get an otherwise meritorious civil rights lawsuit against them dismissed, not on the grounds that what they did was okay, but instead because the particular way in which they violated the person's rights was not already the subject of a pre-existing court case. And therefore, that particular way of violating somebody's rights was not clearly established in law, and so they get a free pass. And it works just like you would think it works. It works to get rid of meritorious civil rights cases brought against rights-violating police or other government officials for the mere happenstance that there's no pre-existing case on the books with pretty much the exact same facts. And so does a lot to undermine our nation's civil rights laws, which were written after the Civil War and designed to provide broad relief to people whose rights are violated, and qualified immunity frustrates that purpose.
I might be missing something with this, because if the idea is that there has to be a pre-existing court decision or a pre-existing law in order to overcome qualified immunity, but if there is no pre-existing law, so you can't overcome it, how do you ever establish the law to begin with?
It's a great question, and your instinct is exactly right. What many judges, or some judges, have noted is that among its many problems, qualified immunity has the effect of kind of stagnating the development of the law. And we've seen this in a number of cases where I'll give you an example. There was a case in Colorado where somebody sued the police for interfering in his ability to record them. They were performing a very violent drug arrest, and so he recorded them. They came over and hassled him and took away the tablet he was using to record and tried to delete the footage. Now, every court that has looked at the question says there is a constitutional right to record police in public, and they testified that they were in fact trained by their own department that there is a right to record them in public that they should not interfere with. But when they were sued, they asserted that all of that might be true, but the particular court in our jurisdiction, which was the 10th Circuit Court of Appeals that covers Colorado, has not yet weighed in on this issue. And so therefore we should get qualified immunity, case should be dismissed. Not only did the court agree with them and dismiss the case, but it didn't take a position on whether the right to record police was protected in that jurisdiction going forward. And so it remained an open question. Now, courts can answer the question if they want to, but they don't have to. And typically they don't. And so the question of whether the conduct at issue in that case, such as recording police, is in fact a violation of somebody's civil rights remains unanswered until some court comes along and decides they feel like answering it. And it's every bit as bad as you think it is.
Now, qualified immunity is basically a preemptive defense, right? And what I mean by that is it's not as if you go to court and you have your case heard and then they decide. They decide ahead of time that qualified immunity applies, and then your suit can't be brought, correct?
That's right. It's a personal defense available to police and other government officials. They can decide whether to assert or not assert it. And when they do, it's what we call an affirmative defense. So they have to make an argument that they're entitled to qualified immunity. Then the burden shifts back over to the plaintiff to identify some pre-existing case with nearly identical facts that should have put them on notice that they shouldn't have done whatever it is that they did. And if the plaintiff can't find that pre-existing case, then the qualified immunity defense will be granted. The case will be dismissed, even if the court recognizes, as they sometimes do, that there was in fact a rights violation. The court will still say, well, this guy did violate your rights, but there's no case on the books already that says that it was a rights violation, so I got to give him a free pass.
Now, judges and the attorneys that represent government employees are themselves government employees. Are they protected by qualified immunity?
It's even worse than that. Judges have what's called absolute judicial immunity, as do prosecutors, and it's just what it sounds like. Prosecutors and judges simply cannot be sued for civil rights violations. So it's not even qualified, it's absolute. There's very minor exceptions where if a judge does something that's completely outside, of the judicial role, even though they're wearing a robe at the time, and that would be, I don't know, an example would be
Like if he hits you with his mallet or something?
yeah, that's right, something like that. Or if a prosecutor commits a rights violation while engaging in conduct that's not within the typical role of a prosecutor. So, for example, if they're participating in an interview with police detectives where they lie to the suspect or help frame somebody, which happens sometimes, then at least in theory they can be held liable. But they fight like hell to essentially for a very broad interpretation of this absolute immunity. So your premise is exactly right. Judges work for the government; they are shielded from immunity, and it's worse than that. A wildly disproportionate number of judges are themselves former prosecutors or other courtroom advocates for government. So something like half of the federal judiciary, we did a study on this, about half of sitting federal judges served as courtroom advocates for the government before becoming judges. And I can tell you from my own personal experience on the other side of that fight, it definitely will shape your worldview. It's not to say you can't be a good judge if you used to represent the government in court, but when you have that many judges who have that prior experience, it's definitely going to, I would say, influence the shape of legal doctrine and the attitude of judges towards these kinds of cases.
So, although absolute immunity differs from qualified immunity, it isn't a stretch of the imagination to figure that if qualified immunity is cut back or done away with, that absolute immunity might also be on the chopping block. How is it not a conflict of interest for judges to rule in these cases?
Yeah, no, it's that's a great question, because like, who should you go to get a resolution of whether this entire branch of government is entitled to this form of immunity? I will say this: I don't think that's really where the action is when it comes to civil rights violations, because of course in our system, you have the ability to appeal a judge's ruling, and there are channels that you can essentially access to if you think that the judge has committed a legal error. And unlike prosecutors, judges don't go out looking for people to to prosecute. Unlike police officers, they don't go out looking for people to arrest. So judges are, I think, much less a part of the problem here. The real action here, I would say, is with police who violate people's rights, and with prosecutors who sort of go outside of established procedures in ways that violate people's rights. They get way too much insulation from their misconduct, both police and prosecutors. So that's where we need to dial back, in my opinion.
Well, I don't disagree with you that most people, when they have their rights violated, it's going to be at the street level where their interactions with the police, because that's who they most interact with. But if not for the judges giving them cover, then these police and prosecutors wouldn't get away with it. And so with that, what are the origins of qualified immunity?
Yeah, that's a great question. So as I mentioned before, our country's primary civil rights law is sometimes referred to as Section 1983. In fact, that's what it's usually referred to, because it appears in the U.S. Code at 42 U.S.C. Section 1983. But its original name was the Ku Klux Klan Act, and it was enacted in 1871 to empower the federal courts to provide a remedy to citizens whose rights were violated by so-called state actors. That means anybody who works for the government at the state or local level. And of course, there was a tremendous amount of oppression and tyranny committed by, let's say, a Southern sheriff who wears a badge during the daytime and a hood at night. And so that's what the origin of that law was. In 1967, a case came to the Supreme Court where some police had arrested some ministers who were sitting at a segregated lunch counter in Mississippi. And the law that they were enforcing when they made that arrest was later determined to be unconstitutional. And when they were sued, they asserted what they called a good faith defense and essentially said, look, we're just cops. We were enforcing a law that was on the books at the time and that we had every reason to believe was constitutional. And so, we shouldn't be liable for just enforcing a law that was on the books because it was later found to be unconstitutional. The Supreme Court accepted that argument and said, okay, yes, there will be a limited good faith exception. And if they had stopped there, I would still disagree because it's up to Congress to decide when to make exceptions, not the Supreme Court, but it wouldn't be doing very much work in our system. What happened, though, is that in a subsequent case, in 1982, a case called Harlow v. Fitzgerald, the Supreme Court took a gigantic step in the direction of more immunity, where they introduced this clearly established concept that I mentioned earlier, where now it's not just a matter of, well, I was enforcing a law that was on the books and I didn't know it was going to be found unconstitutional. And instead, the court said that in order to hold a police officer or other government official liable, you have to be able to show that whatever it is they did to you, it was clearly established at the time that that was improper. And the way to do that is to identify a pre-existing case with nearly identical facts. And of course, that's just going to be both rare and complete happenstance as to whether such a case is already on the books. And the rationale for it was frankly, totally made up out of thin air. And essentially what the Supreme Court said was, well, this is to ensure that police are on notice about what they're allowed to do and what they're not allowed to do. And the idea that police officers on their off-duty time, stay up at night reading court opinions and then have the ability to recall, both the facts and the holding in the middle of heat of the moment when they're deciding whether to shoot a fleeing suspect is completely preposterous. And in fact, there's scholarship by Professor Joanna Schwartz, who's a wonderful qualified immunity guru, that demonstrates that that is not at all what happens. But that's basically the origin. The Supreme Court decided to get in the policy-making business and, in effect, amend a federal law passed by Congress to insert a defense that Congress did not put in that law, simply because the Supreme Court thought that would be sort of a better and more fair approach. And I would say it was one of the most glaring examples of actual judicial activism that I've ever seen. And again, just a blatant example of judicial policymaking that the Supreme Court has refused for the last 40 years to defend in any meaningful way or to revisit, notwithstanding all of the the growing chorus of scholarship and activism that has been criticizing qualified immunity.
Now, as long as I've paid attention to politics, conservatives have railed against judicial activism. We need original meaning, strict construction. They shouldn't be reading, judges should not be creating rights or legislating from the bench. In my home state of Connecticut, there was actually a law passed that significantly scaled back. It may even have abolished qualified immunity. I haven't read the law. I've just listened to the political debates about it. But as far as I know, to a person, the conservatives in our legislature in this state want qualified immunity for the police. And I tell them every time, whenever I discuss it with any conservative, well, how is it that you're so opposed to judicial activism, but in this case, you're for it? Because judicial activism is supposed to, when you're opposed to it, it doesn't matter if you actually like the policy. It's the form that matters. We're supposed to be a constitutional republic. The Constitution governs. And I remember years ago, I read a book by Randy Barnett, Restoring the Lost Constitution. And he said that one of the ways you can tell if you're being honest is if you will uphold an opinion that goes against what you actually like. And I'm reminded of Antonin Scalia saying that he's 100% against flag burning, but nevertheless, it's protected by the First Amendment. But if all you're doing is saying, I love the Constitution when it does what I want it to do, then you're really not much of a constitutionalist, right?
Yeah, you're spot on. I actually wrote a piece about this where I pointed out that qualified immunity flies in the face of a variety of bedrock conservative commitments. The first one you've already mentioned, which is a very strong commitment against judicial policymaking. Judges are supposed to apply the law, not make it. And qualified immunity was invented out of whole cloth by the Supreme Court in a blatant act of judicial policymaking. And guess who doesn't seem to have a problem with it? Basically every conservative I've ever met. And their response tends to be, well, it's been on whatever the origins of this defense, it's been on the books for 40 years now, and Congress hasn't changed it. So somehow that sort of eliminates, the taint of this initial act of judicial policymaking. But let me assure you, if it was any other example of the Supreme Court making things up and they didn't like it, they would absolutely not say that congressional acquiescence was somehow validates, the initial act of judicial lawlessness. So you're exactly right. All that's going on here is that they like this policy, and so they rationalize their failure to oppose this blatant act of judicial activism. But it's important to keep in mind two other values that conservatives supposedly embrace that qualified immunity undermines. One is limited government, right? I mean, this is an incredibly empowering doctrine. Makes it impossible for ordinary citizens whose rights have been violated by the police and other government officials. It's not just the police. It could be a college administrator who censored your speech. That's something that's going on right now. And guess what? They get qualified immunity. So it's not just police. So this is an incredibly empowering doctrine that enables government officials to get away with all kinds of rights violations. You would think, again, the conservatives would be against that, but nope, not when it comes to qualified immunity. And then finally, of course, conservatives are supposed to be all about personal responsibility, right? And yet, when somebody plausibly alleges that a police officer or other government official has violated their rights, personal accountability goes right out the window, and we allow this person to assert qualified immunity so that those claims never even make it to a neutral adjudicator. So yeah, conservatives have a lot to be, I think, ashamed of here in terms of their support for qualified immunity. It is a naked policy preference that flies in the face of at least three of their most important purported commitments. And their attempts to defend their support of qualified immunity are frankly pathetic.
Now, the language of the qualified immunity, to bring this down to more concretes, is basically if a rational person or a reasonable person wouldn't know that it was a rights violation, then you can't hold somebody responsible, right? That doesn't sound as bad as for instance, there has to be pre-existing law, or what I'm guessing are some real life examples. So put some meat on this. What are some real life examples where this has been abused?
Yeah, so let me preface it by saying, again, you're exactly right. Part of the problem is that the Supreme Court has articulated qualified immunity in a bunch of different ways, and some of them are hard to reconcile with each other. By the way you stated it just now is sort of one of the most limited ways to put it. Another way they've put it, and the way they most commonly put it, is that in order to avoid qualified immunity, you have to show that every reasonable police officer or other government official would know that what they did was wrong. And this is the one that kills me. They say that the purpose of qualified immunity is to protect all but those who knowingly violate the law or the plainly incompetent. Now, let me ask you to imagine, would you go to a hospital or fly with an airline that had that standard for doctors and pilots, that our policies are here to protect all, everybody except those who knowingly violate the law or the demonstrably incompetent? No way, I'm not getting on that plane. But that's the Supreme Court's vision of sort of what government officials need in order not to be sort of held liable willy-nilly. Yes, and I'll give you some examples of cases where qualified immunity has been granted. One is called Jessup versus City of Fresno. So this is out in California. A police officer is serving a warrant at a home, and in the bedroom he finds $225,000 in cash and gold coins, to which he just helps himself, literally puts them in his pocket. He doesn't put them in an evidence bag. He doesn't bring them to the station. He just puts it in his pocket and keeps it. The homeowner then sues, and the Ninth Circuit Court of Appeals, which covers California, says, well, listen, look, we all know that it's wrong morally to steal from somebody, but we don't have a case on point that says it's actually a Fourth Amendment violation to steal somebody's stuff while executing a search warrant in their house. So this guy gets qualified immunity. You think I'm joking? I'm not joking. That's a real case.
That's
another
insane.
Example, yep, it is insane. Another example from the 11th Circuit in Georgia, there was a police pursuit. The officer catches up to the guy on the front yard of a family's property. There's a bunch of kids and grown-ups outside playing and hanging out. The police officer tackles the guy, has him laid out, and he makes everybody else lie down too so he can control the scene. And while he's, I think after he has cuffed the suspect, a dog emerges from underneath one of the houses, not threatening, not growling, just comes out from underneath the house. And this officer, with this yard full of kids and grownups lying down, starts shooting at the dog. He misses the dog. Dog goes away. A few minutes later, it comes back. He fires off another round of shots, and this time he strikes a 10-year-old boy who's lying a foot and a half away from him in the back of a leg, severely injuring him. Again, the cop is given qualified immunity. That is an absolutely insane use of lethal force. But again, the rationale is, well, we're not saying that what he did was right, but we don't have a case on the books where a cop had a yard full of kids and grown-ups lying down and he cooked off a bunch of shots at a non-threatening dog. So how is he to know, right? I'll give you one more example. This one in some ways is the most vivid. This is a case called Kelsey v. Ernst from Nebraska. A woman was at a public swimming pool with her boyfriend and her kids. They're horsing around in the shallow end. Some people misinterpret it, call it into the police as a possible domestic. The police show up. They get the boyfriend and Miss Kelsey out of the pool, separate them, interview them. While she's being interviewed, and again, keep in mind, she's not the suspected perpetrator. She's the suspected victim. She notices that somebody's hassling her kids. So she says to the police officer, hey, I need to go deal with my kids. I'll be right back. And he says, no, you need to stay and talk to me. And she says, I will talk to you, but I got to go help my kids. So she turns and begins walking away. He comes up behind her, gets her in a bear hug, lifts her up off the ground. And keep in mind, she's about 5 foot tall, wearing a bikini, no weapons. Lifts her up off the ground, turns her upside down, and body slams her into the ground so hard that she's knocked unconscious and her shoulder is broken. She sues. He asserts qualified immunity. Again, and this is going to be a theme, nobody's saying what he did was right. It's just that there's not a case on the books where a cop lifted up a 5 foot tall woman wearing a bikini and body slammed her into the ground. So did he get qualified immunity? He did. He got qualified immunity. So that's how it works in real life. Whatever assurances judges or other supporters of qualified immunity might give us that, well, or police themselves, oh, it's only supposed to protect reasonable decisions. It doesn't protect people when they violate the law, et cetera, et cetera. Complete garbage. That is completely misleading. And I can give you case after case where police who have committed glaring civil rights violations and even crimes were granted qualified immunity simply because the specific thing they did was not the subject of a prior court case. It's a garbage doctrine that produces manifestly unjust results, and I would say severely undermines public confidence in and respect for police, because what people begin to realize is, hey, we are being held to a massively different standard than police. I'm held to this standard way up here when it comes to compliance with the law, and police are held to a much lower standard way down here, and that's not right. And you know what? They're right. That isn't right.
And what about the idea that ignorance of the law is no defense? Why doesn't that apply?
It's a great question, right? Because if you are arrested and prosecuted for engaging in conduct that you didn't even know was illegal, and you're like, I didn't even know, that's not going to be defense, because you're right. Ignorance of the law is no excuse. On the other hand, and by the way, think of the difference in the stakes. This is your liberty on the line. If you lose that case, you don't just have to pay some money. You're going to jail, right? You're going to lose your liberty. And the courts are not at all protective, and they're not at all receptive to the argument that, oh, I didn't know that what I did was not okay. Now flip it around, and it's a police officer or another government official. They're not going to jail. The only question is whether they're going to be held liable for violating somebody's civil rights. That's all that's at stake is money. And by the way, it's not going to come out of their pocket. We know from scholarship that demonstrates that police almost never pay damages awards out of their own pocket. Why? Because they're indemnified by their employer, the city or the department, which is to say us, the taxpayers. So there's very little at stake for a government official who's asserting qualified immunity. And yet here you have the court saying, oh, it would be so unfair for you to be held liable for something unless there was a court case, by the way, that you never would have read anyway, on the books to provide you with notice. And you're exactly right. It gets it exactly backwards. And there's a wonderful discussion of this point in a case that came down earlier this week from a Mississippi federal district court judge named Carlton Reeves, who has criticized qualified immunity before. He had an opinion that came down this week. I just wrote a piece about it for the Bulwark. It is amazing. It's a total takedown. And the last bit of the opinion is so powerful because he focuses on exactly this point and explains, kind of how unfair it is that ordinary citizens are held to this very high standard of knowing what the law is, Whereas police who are actually trained in the law, at least theoretically, are held to a much lower standard when the stakes themselves are lower. But it's such a vivid illustration of our criminal justice system and our justice system writ large. Government officials get so much largesse from the courts, so much leeway compared to what we ordinary muggles get when we're in a similar position. And I certainly can't justify it. The best I can do is describe it and tell you that it is absolutely the way the system works.
Now, I have no problem understanding why there's politicians that support the policy. The police have a very strong union. The politicians want their votes, plus the politicians themselves are covered under qualified immunity. But why do so many average citizens support it? Like, what are they being told, or what's the rationale that leads people to support this? Is it just blind support for the police?
I think to the extent somebody supports qualified immunity, that's probably the best explanation. But two things that are important to keep in mind. First of all, we've done polling for the last several years, and a significant majority of people, when you explain qualified immunity to them, do not support it. They reject it. And so it really doesn't have broad public support. Most people don't know about it. When you explain it to them, their response is, no, I don't support that. But yeah, second, I think that when people do support qualified immunity, in my experience, they support what they think is qualified immunity because they've been given a version of it that has no basis in reality. One of the things that's been so dismaying is how consistently police and police organizations distort the actual qualified immunity defense when they're trying to argue that it shouldn't be taken away. And we've written a blog post on this, just how consistently and grossly they misrepresent what it's about. So, for example, saying, oh, well, qualified immunity doesn't protect a police officer who's violated the law. Oh, it absolutely does. And it does protect sometimes criminal acts. So I think there's a lot of misinformation out there.
Speaking of misinformation, one of the arguments that I hear is that when they took away the qualified immunity here in Connecticut, that, we had an uptick in crime, especially in juvenile crime. Now, as a person that was a serious juvenile delinquent, I can absolutely assure anybody that juveniles are not up to date on the latest changes in qualified immunity law. Like, there was never a time in my life when I was committing crime that I said, oh, wow, the legislature really granted me a big win here. The people just don't know that. But it is when people are afraid for their safety or their property, their cars are being stolen and they're being told this is because of this change in the law, demagogues play to fear. So I guess that's kind of what you do, is you want to bring it to the public's attention that their fears are not justified by the facts, that this is bad law and it needs to go away, right? Is that part of what you do?
Yeah, absolutely. The one thing that's so important to remember, especially with all the propaganda that's flying around, is crime is one of the most complex questions of public policy and social dynamics that there is. And anybody who tells you that because X happens, then Y happens with crime is full of it. It's not the way that it works. Now, there are some explanations that are more persuasive than others. And I'll give you one example that is adjacent to this area. I think one thing that is fairly clear is that if you get an incident of widespread depolicing, which is to say when police pull back, they don't go out on patrol, they sit in their cars. And this happened, for example, after the Michael Brown shooting, in Missouri. And it happened in Baltimore after an incident involving a guy named Freddie Gray, who was paralyzed after being given a rough ride in a police van. There is frequently a significant uptick in crimes that are associated with this kind of depolicing. And I've heard, from people who actually work in Baltimore, for example, that people who may have been waiting to settle a score on the street will go out and take that opportunity to do that. So it's not that there's nothing to this whatsoever, but keep in mind that when police pull back like that, that's not a valid act of sort of civic protest.
It's a dereliction of duty, isn't it?
That's right. That is absolutely a violation of their sworn oath. because essentially what they're doing is they're being petulant. They're saying, oh, well, if you're going to hold me to this standard, or you're not going to give me qualified immunity or whatever, then I'm just not going to do my job, or I'm not going to fully do my job. Let me say one more thing that I think is really important. I know plenty of police officers who are really good people and go out there and try to do a difficult job honorably. And they don't want any part of qualified immunity. They don't need it. They don't want it. And they understand perfectly well that the public perception that there's this special defense that's available to rights violating police officers that's not available to ordinary people like us undermines public support for police because it's not fair, it's not right. And their attitude is, look, I have no problem going in front of a jury and explaining to them why I did what I did, even when I make a mistake. We sometimes make mistakes, right? As police officers, we have to make decisions, snap decisions under conditions of uncertainty and often danger, and we're not always going to get it right. Well, guess what? A good cop will be able to go and explain that decision to a jury and is not afraid to do so. That's why they don't need qualified immunity, because the kind of leeway that they say they need is already built into the relevant legal standards. Cops are not held to a standard of perfection, far from it. And we know from a long history of how civil juries respond to lawsuits against police that people are going to give cops a lot of leeway when they're out there trying to get it right, even when they make a mistake. Where cops need to worry is where they've engaged in behavior that is so out of line that when they try to explain what they did to a jury, that jury's going to look at them and be like, nope, that was completely out of line, and you were not plausibly trying to do your job and get it right. You were abusing your authority. That's what really scares them, is knowing that sometimes that's exactly what happened, and they don't want to have to try and explain that to a jury because they can't.
What do you think the future holds for this doctrine? Is it going anywhere? Is there a real movement to get rid of it, or is it just in some liberal states?
It's a great question. I don't know the answer to that, but what I see from my standpoint, I've been working on trying to get rid of qualified immunity for coming up on 6 years now, is that you've got a tension between two really powerful forces, almost like tectonic plates, that are pressing against each other, and you're waiting for that earthquake or the volcanic eruption. And the two pressures are this: qualified immunity is completely indefensible. It is completely indefensible on the law. It's indefensible as a matter of morality, and it's indefensible as a matter of policy. It is a garbage doctrine with garbage origins. So that's pretty powerful. On the other hand, you have what is arguably the most or second most powerful political lobby in the country, which is law enforcement. That's police, prosecutors, and prison officials. And not only do they love qualified immunity, they've come to believe that they couldn't do their jobs without qualified immunity, or in the case of prosecutors, absolute immunity. And I would say that preserving immunity is one of the top 2 or 3 priorities that they have as an institution. And when police and prosecutors throw their political muscle behind something, in this case, getting a free pass for their rights violations, it's going to be very difficult to oppose them. So we've got the opposition of these two strong forces: the complete indefensibility of qualified immunity on the one hand, and the strong commitment of one of the most powerful political lobbies in the country to maintaining it. How is that going to shake out? I don't know, but my sense is that we are getting the upper hand gradually, because qualified immunity is so indefensible, it is so unfair, and it produces such wildly unjust results that even proponents of qualified immunity will not defend. They'll look at that like, well, that's I'll agree that shouldn't have happened. But it's just, it's a very limited example. And then the answer is, well, no, it's not. It's not. So, I think ultimately we're going to see qualified immunity dialed way back, or perhaps even eliminated, but perhaps not on the time frame that I had hoped, which is the next few years. In the next 10 or 20 years, probably, but in the next few years, unfortunately not. I think the strength of the law enforcement lobby is just too powerful, and they're too committed to maintaining this unjust and unfair legal defense.
Okay. Well, before I let you go, is there anything that you'd like to add about the topic?
Yeah, I mean, I think just that people, I hope, will go out and educate themselves about this. It is extraordinary. I have never seen another public policy issue that had broader cross-ideological support. We filed multiple briefs that we call the cross-ideological brief, where we've got everybody from the ACLU and the NAACP on one hand, to Alliance Defending Freedom and some other conservative groups, libertarian groups like Cato and the Institute for Justice in the middle. The one thing those groups, there's nothing else they all agree on other than we need to get rid of qualified immunity. We've even worked with Ben and Jerry's ice cream. Believe it or not, they're trying to get rid of qualified immunity. So it's gratifying to be able to identify an issue that has such broad support among the public and among organizations that are trying to bring justice to public policy. And really, the only opponent we have are the people who benefit from qualified immunity because they don't want to answer for their rights violations. So ultimately, if the public will educate themselves about qualified immunity, get involved, even if it's just a matter of writing to your representative, telling them, look, it's time to get rid of this, I think we can get it done. Excellent. Okay, Clark. So where can people find you? Yeah, so we are the Cato Institute, which is a libertarian think tank here in DC. It's cato.org, cato.org. And we also have a qualified immunity website that's the most comprehensive one-stop shopping resource for everything having to do with qualified immunity. And that is unlawfulshield.org or .com. Just type in unlawful shield into Google and you'll go there. And we have everything you could want to know about qualified immunity, including a really great FAQ. And we invite people to come and check that out as well. Unlawful shield. All right. Well, thank you very much for taking your time to explain this to us. And for now, this is the Rational Egoist signing out. I'm Michael Liebowitz. Until next time.